What did the prosecutor request on 19th December in relation to the Kenyatta case?
The prosecution has sought an adjournment of 3 months from the 5th February 2014, the provisional date currently scheduled for the opening of the trial in the case against Uhuru Kenyatta. The Office of the Prosecutor has asked for this adjournment after the recent withdrawal of 2 key witnesses from the prosecution's witnesses list. In the last 2 months, one of the prosecutor's important witnesses in the case has indicated that he is no longer willing to testify. More recently, on the 4th of December 2013, a critical second witness in the case recanted his testimony regarding a crucial event in the prosecution's case. Giving false testimony is clearly a matter of utmost concern. In the light of these recent developments, the office believes that the evidence does not now satisfy the high standard of proof required at trial. The office has requested the adjournment in order to complete investigative steps. At this stage, the prosecutor does not consider appropriate to further explain these investigative steps, as making the details public would defeat their purpose. The prosecution has also requested that the Chamber convene a status conference in the last week of January 2014, in which the prosecution will update the Chamber on the progress of the investigative steps and answer any questions the Chamber may have. We cannot speculate on the Chamber's future decision. The judges of Trial Chamber 5B guarantee the fairness of the proceedings and will announce their decision on this request in due course after receiving observations of the defense and the victims' legal representatives.
Is the prosecutor requesting this adjournment because of political pressure or because the accusations were based on rumors?
The prosecutor's requests, as well as the judge's decisions, are taken independently of any political consideration. The prosecutor acts in accordance with the Rome Statute legal framework and is guided solely by the facts and not rumors, and by the evidence gathered during an independent and impartial investigation. The prosecutor also has the obligation to continuously assess her evidence in order to decide whether such evidence would, in her view, be sufficient to meet the high evidentiary threshold required at trial.
Could this be a pointer that the prosecutor is preparing to drop the charges against Mr. Kenyatta, as it happened in the Mudhaura case?
The prosecutor has simply requested an adjournment to allow the prosecution additional time to follow some leads and investigative steps. For now, the judge's decision on the request, as well as the future of this case, should not be the subject of any speculation.
What assurances are there that the victims of the 2007-2008 post-poll chaos will still get justice?
Any delays or postponements must be very disappointing for the victims in this case. As the prosecutor of the court has stated, the Office of the Prosecutor will firmly continue to do all it can, without fear or favor, to realize justice for the victims of the 2007 post-election violence in Kenya. It is because of the office's commitment to the victims in this case that the prosecution is asking for more time to reassess the case and undertake all remaining possible investigative steps to strengthen the case in an attempt to ensure justice for the victims.
What impact has the quality of the government of Kenya's cooperation with the prosecutor impacted on the preparation for trial?
The Office of the Prosecutor has publicly stated that Kenya has failed to cooperate with the office. Specifically, on the 8th of May 2013, the Office of the Prosecutor made submissions to the judges on the status of its cooperation with the government of Kenya. Then, on the 2nd of December 2013, the Office of the Prosecutor made a specific request to the Chamber for a finding that the government of Kenya has failed to comply with the prosecution's request for financial record of the accused. According to this filing, the government of Kenya has failed to provide important evidence to the Office of the Prosecutor. The prosecution alleged that, although it had asked for these records in April 2012, the government has failed to provide important information regarding Mr. Kenyatta's bank records in 2007 and 2008. As a state party to the Rome Statute, the government of Kenya has the obligation to cooperate fully with the court. Full cooperation entails executing requests fully, effectively, and in a timely manner. The government has the right to respond to the prosecutor's request for a non-compliance finding. The judges will decide in an impartial manner on this request upon receipt of the parties and the government's observations. In case the judges grant the prosecutor's request, the court may inform the Assembly of 122 states parties of the non-cooperation, for this Assembly to take any appropriate measure to ensure Kenya's full cooperation with the court.
Would this latest application by the prosecutor have any impact on the ongoing case against Mr. William Ruto and Joshua Sang?
The prosecutor's request to Trial Chamber 5B for postponement of the trial's date applies only to the Kenyatta case. It does not apply to any other case. The trial of Mr. Ruto and Mr. Sang has already opened and is continuing before a different trial chamber.
How does the prosecutor select her witnesses, and how many witnesses is she still calling in the Kenyatta case?
The Office of the Prosecutor makes assessments of the best evidence available to it and tests those evaluations constantly. Calling credible witnesses is a key foundation of the judicial process. However, it is ultimately for the judges to decide on the credibility of the witnesses of both parties, following the hearings and the cross-examinations of these witnesses. According to its public filings, the prosecution is calling approximately 30 witnesses in the case against Mr. Kenyatta. As the prosecutor explained in her statement, the two witnesses who have recently been withdrawn from the prosecution's witness list are individuals who had previously offered key evidence regarding the alleged role of Mr. Kenyatta in the 2007 post-election violence in Kenya. For that reason, the prosecutor has asked the judges presiding over the case for more time to undertake all remaining steps possible to strengthen the case in an attempt to ensure justice for the victims.